Good evening. We welcome you all to the third webinar series of Lex Veda. Lex Veda is a knowledge sharing series where we endeavor to invite legal experts to speak on various fields for the benefit of the legal community. We have successfully had 2 webinars on the field of civil law. Today, we are going to have a very unique topic from a very renowned public speaker from the Supreme Court of India, who is going to speak on the topic constitutional perspectives in identification of backward classes. Before I introduce the speaker, Shri Anirudh Sharma ji, we welcome you, sir, for this webinar series. Shri Anirudh is an advocate on record on Supreme Court in the Supreme Court of India. Has been practicing since 2011. He's an eminent author, columnist, and a public speaker. Anirudh has completed his LLB from the Campus Law Center, Delhi University. He's done his MA from the Delhi University and is a third rank holder. He has worked with eminent lawyers like Shri K. Parasaran sir, who is a senior advocate and an erstwhile solicitor, former Attorney General of India, and also has worked with Shri Harin P. Rawal sir, who is also an additional Solicitor General of India from 2005 to 2008. Anirudh ji has assisted the court on various diverse subjects before the Supreme Court, including constitutional law, criminal law, civil law, direct and indirect taxation, foreign trade, and service law. Anirudh ji has qualified as an advocate on record in 2011 and has been in independent practice since then. He has appeared before various forums besides the Supreme Court of India in the High Court of Delhi, High Court of Patna, High Court of Guwahati, Bangalore, and Ahmedabad, the National Consumer Dispute Redressal Commission, CAT, NCLT, and the PI bar. He has dealt with various constitutional subjects, including the Constitution 93rd Amendment Act in the Ashok Kumar Thakur case and the Constitution 85th Amendment Act in the Nagaraja Union case. Besides constitution law, he has worked on various important topics in the corporate commercial law, service law, indirect taxation, criminal law. And to his credit, there are various reported judgments numbering to more than 20. And to name some of them, including the Lalita Kumari case and the Caterpillar India Private Limited versus Western Coalfields case. To his credit, he has various publications on various topics, including land acquisition law, insider trading, constitution law, etc. We are extremely delighted to have you with us today, Shri Anirudh ji. And I would refrain myself from introducing the topic, since after having spoken to you, I realized that I would not be able to do any justice by introducing the topic. So without much ado, I think we should jump straight onto the topic, and we are really excited and looking forward to listening from you.
Before the speaker starts to speak, may only give one introduction to the speaker. Like Swati has already indicated the versatile experience of Anirudh ji, but one personal experience when I was an intern in Delhi. In fact, the case which Swati had just referred to, Ashok Kumar Thakur, was being argued at the Supreme Court. And I've seen Anirudh sir participate in those proceedings. And actually, Indra Sahani's judgment, which is like supposed to be the Bhagavad Gita on this subject, I don't think many of us have actually had an occasion to read the entire judgment. But Anirudh is one person, you wake him up even in the midnight, he would tell which judge said what in that judgment. So I think he's one person who's a master of Mandal judgment in terms of, I was really amazed at the manner in which he had studied Indra Sahni's judgment, and he had the insight with which he was briefing the senior advocates who were representing the case before the Supreme Court. With this preface, I may now invite Anirudh to enlighten us on various aspects of the issue, especially the constitutional perspectives on identification of backward classes. Actually, the topic has relevance because I think if I may just quote Arun Shauri from his book Falling Backwards. Earlier, I think what he said was there was a race to get identified as the forward classes. But now the race seems to be to get identified as a backward class. And in light of this trend in the country, because at some level, it is important for the future of our nation that the correct deserving classes are only recognized as backward classes. I think today's perspective, which Anirudh sir would share with us, should create a way forward for the nation as such. May I request Anirudh sir to start the session.
Thank you, Pawan. Pawan has been a bit more kind to me than what I actually deserve. So coming to this topic, this is a topic which generally brings out a lot of controversies. So my perspective in this session would be to bring to you the topic as it has been interpreted by the courts and not any one particular perspective. So when we talk about constitutional interpretations, only among the backward castes, among the backward classes, only the other backward classes and the SEBC, socially and educationally backward classes, are not defined, were not defined in the Constitution. A recent effort has been made to define them, but we'll have to wait for the court's interpretation on those newly introduced articles to see if they get a new definition from the court, or the court interpretation is also similar to that what the Parliament has defined. Because the final authority in terms of constitutional law as to what particular provisions mean or indicate would be the court. So when we are talking about generally affirmative action, the first question that comes to our mind is affirmative action is for whom? So affirmative action is generally for the weaker sections. But then weaker sections again can include a diverse range of groups, individuals. So from the larger subset of a weaker section, the present constitution chooses a subsection for reservations. Affirmative action can have various other means as well. Poverty alleviation, we have seen free ration, free houses, or Ujjwala Yojana. These are all affirmative actions for the weaker sections. But when we come to reservations, there is a particular problem because the word reservations occur in 16(4), and then they also in a way are indicated by 15(4) that the state can make any provision. Of course, the law is that even if 16(4) and 15(4) were not there, reservations were still possible as interpretation of Article 14 itself, as they would be reasonable classification within themselves, weaker sections. But what 16(4), 15(4) does is from the weaker section, it enables identification of scheduled castes and scheduled tribes as one community for the purpose of reservation. Scheduled castes, scheduled tribes are of course identified under Article 341, 42, and the whole scheme downwards from Article 338 of the Constitution of India. However, the identification of other backward castes, other backward classes rather, and the socially and educationally backward classes as defined in Article 15 has caused much of a debate and fissures in the society. It has its genesis in certain affirmative action steps taken in mostly in the southern states of India before independence. If we go to Mark Galanter's book, we find that use of the term backward classes was first put in effect in 1880. And this, all these were submitted before the court in Ashok Kumar Thakur. So it's borrowed knowledge from the senior counsels. So Mark Galenter points out that in 1880, use of the term backward classes to describe groups which were illiterate or indigent being entitled to allowance for study in elementary schools was initiated. Then in 1895, Fort St. George Gazette number 40 provided for grants in aid to schools for backward classes consisting mostly of untouchables in the Madras Presidency. In 1917, Maharaja of Kolhapur expressed interest to Montague Chelmsford in uplifting the backward classes and especially the untouchables. But the real action starts when the government of Mysore, for the first time, brings in affirmative action and reservations for the backward classes. And in para 766 of the Mandal judgment, Indra Sani judgment, you will find this particular fact. State of Mysore was the earliest to make provisions. All caste communities except Brahmins were recognized as backward communities. And backward communities and backward caste terms were used interchangeably. Similarly, in 1925, the Bombay province also took the same route, and everyone except for Brahmins, Prabhus, Marwaris, Parsis, and Baniyas were declared as backward classes. So that is on the history. So as we move towards independence, various fissures in the society were seen and sought to be done away with. At the same time, separate electorate was refused as a concept by the Constitution of India. Secularism was adopted, and the state and the Constitution ensured that there shall be no discrimination only with any individual only on the grounds of religion, race, caste, gender, etc. So therefore, the aim was for a casteless society, but then India coming out from colonialism where it had been drained out of its wealth, the famous drain of wealth theory of Dadabhai Naoroji, had a lot of people who could be qualified as weaker sections. Certainly, there were also certain caste challenges in the country, and certain sections required affirmative action. And of course, the scheduled caste and the scheduled tribes were at the top of it. Hence, the Constitution did not leave it to choice. It identified the scheduled caste, scheduled tribes. It provided a method, manner, and therefore there has been quite less debate with respect to scheduled caste, scheduled tribe reservation in the country. But right from Champagam Dorairajan downwards, there has been debate about the SEBCs and backward classes in the Constitution as not defined rather. So the definition has been subject to interpretation of the court. Now, between para 647 to 650 of the Indra Sani judgment, there's a lot of discussion about weaker sections as to what are the other provisions of the Constitution of India that you have to consider apart from Article 16.4 and 15.4 while talking about reservations. You have to take into considerations Article 38.46 as well, because Article 38 obligates the state to strive to promote the welfare of the people by securing and protecting as effectively as it may a social order with just social economic in which justice, social economical and political shall inform all institutions of life. Similarly, Article 46 gives similar mandate to the state with respect to the weaker sections. So as a matter of fact, these articles from the directive principles enlighten the interpretation of OBC and SEBCs in Article 15.4 and 16.4. Hence, backward classes as identified in Article 16.4 and SEBCs as identified in 15.4 will be from the larger group of weaker sections. And since it's open for the state to identify, and there's no particular definition in the Constitution of India, the state can choose a methodology of identifying, not defining, identifying who it seems is entitled for reservation under Article 15.4 or under Article 16.4 or either of these. It will be a policy decision. Identification, therefore, is a policy decision, as there is no method, no mechanism, no abstract, no concrete definition to identify the deserving classes. But yes, everyone knows who the weaker classes could be. The debate has always centered around caste, because generally in India, we have seen when India gained independence, and of course, even till now, we see a lot of poverty, not in the terms as depicted earlier or as depicted by the international media, but yes, there is poverty in this country. And it was generally found that there are close groups of people, and those groups were homogeneous in occupation, in their life standards, in their poverty indices, and those groups were castes. As Article 15.4 says, that the state may make any provisions for SEBCs and scheduled caste and scheduled tribes, virtually equating them. And the definition for quite some time was that reservations could be only provided to those castes which are SC, ST, if you're following castes, or those situated similarly to SC and ST. Hence, Indira Sahni judgment was also faced with this question as to what would be the correct definition. Because right now what we are seeing as of current, that the Supreme Court has refused, or in fact, has struck down provisions bringing in communities like, dominant communities like Maratha and Jats within the reservation fold, on the ground that they are already dominant communities and they are well represented in the various social spectrums and the administrative hierarchy of the state. So the question, therefore, the main question is that who all from among the weaker sections will qualify as backward classes or SEBCs? That is one. Number two, are you really identifying the weaker sections as SEBCs or OBCs, or in that garb of identifying the SEBCs or OBCs, the dominant communities are also trying to get in? These are the two important questions. So faced with this question of, in a secular constitution, which would take every step to do away with any identity divisions that are there in the society and which are indicated in Article 15.1 and 16.1 of the Constitution of India, and also faced with the reality of caste as a medium of past discrimination, the Supreme Court in Indira Sahni was called on to lay down the parameters of what classes could get reservation under Article 16.4 for appointments. The Supreme Court therein was very cognizant of the fact that they are entering into a policy decision as to whether to give reservation or not, whom to give reservation, how to give reservation, is all but a policy decision, as Article 16.4 and 15.4 were held to be only enabling provisions. Enabling provisions would indicate that they just enable the state to take policy decisions. They are like water. Whatever color you mix in the water, it will take that. Enabling provisions are like that glass of water which can take any color. They were not fundamental rights. they were also not rights coupled with duties, because the segment of SEBC and OBC has been changing, because there have been more and more addition to the list of SEBCs and OBCs. Rarely has there been any exclusion. So the list has changed. Maybe there has been only addition, not exclusion, but more and more people have become eligible. And because it is not a fundamental right, those who were ineligible in 1960s and those who became eligible in 1990s, they could not have moved the court and for a mandamus to the state that the state must provide us reservations. So it is a dynamic concept, the list of beneficiaries of 15.4 and 16.4, SEBCs and OBCs, at least in law, which has to change with time. The manner in which we also segregate the group within itself is also a policy decision. For example, many states might be having 5 lists. One of OBC, second of MBC, third of EBC, extremely backward, most backward. Tamil Nadu has certain classifications. Karnataka has certain classifications. Andhra has certain classifications. So there can be one unified list of OBCs. There can be a list of OBCs in which there can be subdivisions. What Indira Sahni, faced with such a varied range of lists and varied range of arguments as emanating from caste as a tool of past social discrimination, or the challenges which a secular constitution poses to identification to caste, did was it clarified that it is just laying guidelines. It is not laying an absolute law. Indira Sahni was very clear about it. Number two, we have to take into consideration that there is no debate about identification of scheduled caste and scheduled tribes. Only debate is about identification of other backward classes and socially and educationally backward classes. So Indira Sahni clearly says that we are just laying down guidelines. We are not, because we are not giving an absolute benchmark, because society is going to change. Certain classes, certain communities may well become eligible for affirmative action because of change in time, and certain classes, communities may become ineligible with passage of time. So as far as identification criteria is concerned, because the constitution itself does not define it, and one has to assume that society and times change, Indira Sahni gives a guideline for identification and not an absolute test for identification. Of course, it lays down a 50% limit as a general principle. But as far as identification is concerned, it upholds various modes of identification. The first mode of identification was, the first challenge was, or the first question was that caste cannot be the sole or the dominant criteria of identification of backward classes. To which, to my mind, Indira Sahni agrees with that yes, caste cannot be the sole or the dominant consideration, but it is a very relevant factor in identification of backward classes. And it is not the only factor, and it cannot be the only factor. In a secular constitution, you cannot have a list only dependent on caste identities or on religious identities. So it points out to the Mandal Commission report and says that Mandal Commission report has certain parameters which it seeks to follow. Maybe it has followed or not followed. But if we look at those parameters, that is how we can arrive, or that is one of the methods to arrive at the identification of backward classes or the SEBCs as well. As a matter of fact, apart from the test of caste, Mandal judgment, that is the Indira Sahni judgment, does also highlight other criteria But sticking for now to the caste criteria, in para 782 and 783 of the judgment, it is absolutely clarified that while going ahead with an identification test, one can start with caste as the beginning point and then go to other groups, other communities, other sections. The idea is to cover the whole population because you need a yardstick. Unless and until you cover the whole population, you don't have a general yardstick. Whole population does not mean that one has to go for individual test. The sample that you take has to be sufficient enough. You have to take the whole of society into consideration. Then you have to come to a yardstick and then identify who can be the beneficiary of these provisions. Of course, whatever formula you choose to identify, it will not be perfect. Some of the weaker sections will be left out of the beneficiary provision, as every human effect is imperfect. So will be the policy guidelines that will come. There will always be some loopholes here or there because it's not humanly perfect to make a social formula. You can have a formula of science, but not of society. Hence, for example, if there is a criteria which takes into consideration occupation and income only, that this person has this occupation, for example, he's a street hawker and he has an income less than 5,000 rupees, he qualifies as SEBC. And he belongs to a particular caste in which the literacy rate is less than 50%. That is a valid criteria. However, if someone else takes a criteria as to the type of residence, whether someone has a pakka house or a kacha house, that used to happen, it still happens in the rural areas. Though kacha houses are not disappearing, but there were kacha houses till or mud houses till around 15 years back. Someone takes the formula of a mud house plus less than 1 acre of agricultural land, plus the person has to stay or should have studied in a village, plus his family income should be less than 1 lakh rupees per annum. That will be a valid criteria. So the hawker will get missed out in the second criteria because the hawker, though poor, is in the urban area, while the second criteria only considers rural inhabitants for this beneficiary provision. So this is the latitude which the state has. So the constitutional parameter is wide. Constitutional review in such cases, or judicial review in such cases, is limited. One, that it should not violate 16.1, 16.2 as only being a list of caste or as only being a list of religion, but anything, caste plus anything else will be allowed. Religion plus anything else may well be allowed. But then that anything else, apart from caste and religion, will have to satisfy now the test of reasonability. It means that your parameters should apply to a reasonable man's test. And there should be enough material to justify the action that you have taken. That there has been application of mind. You need not justify, the state may not justify its action as the correct action. Because when we are talking about affirmative action, we are in the social domain. We don't know how our the social formula of choosing a particular section of people from the weaker sections for benefits under 16.4 and 15.4 will pan out in the future. Therefore, while many a times while analyzing reservation, some judgments have said that reservation is a social experiment. And when you are doing such experiment, there is a risk that you may go wrong. And perhaps Rohini Commission, the data that it gives, it might be saying that we have benefited only 25% of those whom we sought to benefit. And as per the media reports, Rohini Commission is saying that at least the central list for the backward classes will have to be split into 3 or 4 zones so as to enable the weaker among the backward classes to get benefit of these provisions. In fact, Mandal also gives a very interesting, Indra Sani judgment gives a very interesting comparison in para 802 between goldsmith versus stone cutters, traditional stone cutters, being in the same list. And it wonders how they would compete together. And if the stone cutter would have any chance against a goldsmith, though they both may be treated as backward caste or backward class or SEBC. Hence, the question of reaching to the weaker section, even if you have had a finalized list, still is very palpable and still remains. So when we come to the constitutional criteria, the quest is actually to reach the weaker sections. How you will reach them